Good morning, everyone. My name is Sydney Redpath, and I am the Director of Communications at Digital Supercluster, and I am very pleased to welcome you to our webinar, Data, Collect It, Own It, Keep It. Before we get started, we respectfully acknowledge that in Canada, we live, work, and learn on the unceded traditional and ancestral land of Indigenous peoples. As much of the Supercluster team is based in Vancouver, British Columbia, we are gathered here on the traditional ancestral territory of the Musqueam, the Squamish, and the Tsleil-Waututh peoples. We encourage you to take a moment to acknowledge the traditional territory that you may be joining us from. As a reminder, this webinar is being recorded and will be distributed to all registrants afterwards. If at any point during the session you have a question, please type it into the chat and we will address them at the end during the Q&A portion. And I will now turn it over to my colleague at Digital Supercluster, Jen Milguy, our program manager, to get started.
Thanks very much, Sydney. Bonjour, everyone, and welcome. It's wonderful to have attendees joining from across the country for this month's IP Focus session. Whether you're new or a returning participant, we're thrilled that you could join in with us for this Thought Leadership Power Hour. Next slide, please. There are important and timely concerns related to the growing need to collect, license, and use data, which organizations of all sizes, across all industries, and as both licensors and licensees need to be aware of. Over these next 60 minutes, the discussion will look at key practical considerations for licensing inbound and outbound data, risks and pitfalls for those licensing and using data, and securing data assets when engaging in a founding round. And as Sydney mentioned, a Q&A portion will follow at the end. Next slide, please. Fundamental to the global innovation clusters is collaborative innovation, setting the framework for projects that address cross-industry challenges while creating technology products and services that can scale across industries and ultimately across the world. Digital's IP strategy supports the development, ownership, and retention of Canadian IP through a number of vehicles, and information sessions with thought leaders like we've today are one example of that. Next slide, please. I have the pleasure of introducing two industry thought leaders with us today. Please join me in welcoming Monica Sharma and Matt Brechtel. Monica is a partner at Clark Wilson in Vancouver, and her practice focuses on complex commercial transactions and agreements involving intellectual property, technology, privacy and data protection, and marketing and advertising matters. She advises clients in a range of industries and stages of business, from startups to well-established companies, and has been recognized by best lawyers in Canada in the areas of technology law, information technology law, and intellectual property law. Matt is co-founder of Seastone IP, a globally recognized boutique intellectual property firm and an experienced IP lawyer in Vancouver that has represented well-known international brands, high-tech businesses, and major public authorities, with clients including Remax, Louis Vuitton, and BlackBerry, defending intellectual property rights and confidential information, trademarks, copyrights, software, designs, and related rights. He advises entrepreneurs regarding the use of IP assets online, navigating novel challenges with trademark use, software and app copyright issues, streaming, and other emerging platform issues, and has expertise in multi-jurisdictional litigation, supporting clients enforcing their IP rights in multiple jurisdictions. Monica and Matt, I hand it over to you.
Thanks, Jen, for the very generous introduction. It's a pleasure for both of us to be here today. I'm going to flip us over to the presentation that Monica and I have prepared. And we're going to run through the presentation. So we're talking today about data, collecting it, owning it, and keeping it. And we're going to build our presentation and give the presentation in two phases. The first phase is talking about what data is as an asset. You know, I've seen a ton of agreements that say, we own the data, you own the data. But data is inherently ephemeral. Data isn't a thing, it's not a car, it's not a house. So what you actually own is a series of rights. And it's important when you talk about licensing it or using it or securitizing it to know what it is you actually own. Because only when you understand what you own can you understand what you can do with that ownership. Next, we're going to talk about data licensing, and this is where Monica is going to come in force. Monica has done a ton of work on data licensing and can provide a lot of important considerations when you're looking at licensing the rights that you have to someone else or engaging in some sort of collaboration. So let's start with the first one, owning data. If you say you own data, what rights do you actually have and how do you have them? Now, one of the biggest problems when talking about data ownership is that it's an asset, but it doesn't really have a legal home. Copyright was created for things like novels, photographs, or drawings or paintings. And trade secrets were traditionally created for secret ways of producing things. But there's no regime that's specifically built in Canada for data ownership. So when you're thinking about data ownership, you're actually thinking about a combination of a couple different legal and practical regimes. So the first one of those is copyrights. The second one of those is trade secrets. The third of those isn't even a legal right, it's possessory rights, the ability to control who accesses and uses data. And finally, and I'm going to hit on this briefly because most people don't think about it, is you can actually have certain patents that have effects on data rights and ownership and use. They can all play a role. So I'm going to go to the next slide. This is your cheat sheet, and we'll be distributing a PDF version of our presentation afterwards. But in a snapshot, these are the main legal regimes that I'm going to talk about when we talk about data today. There's copyright, there's trade secrets, and there's potentially patents. And for each of them, there's a different way of creating that right. There's a different way of controlling and assigning that right. And there's a different series of legal risks that are presented. You might get sued for or not doing a certain thing. I'm not going to deal with this. I have the slides below that go into detail on each of these. But here's your cheat sheet for later when you want to go back and see what the rights are. So let's start here. And I want to talk about what the rights are and how they're created. Because before a right is created in data, you own nothing. The general rule, whether it's in respect of trade secrets or copyrights or patents, is you simply can't own a fact. There's no such thing as truly owning a fact. So what you need to do is take a fact and configure it or build it in a particular way before you can get legal rights. And then you need to track what legal rights you have in what configuration of that data. And that's going to diverge to some degree, whether you're relying on a copyright or on a trade secret or on a patent. Copyright, at a very high level, is granted to a work which can be a compilation, a collection of things that involves skill and judgment. And that sounds vague because it largely is. It's a test that was created by our Supreme Court almost 20 years ago now that said, when you put together discrete pieces or ideas and you use human skill and judgment to do it, the resultant work is protectable by copyright. And I'll give you some examples to put some boundaries around that so you're not just floating off in the ether when you think about whether you have applied skill and judgment. The second type of legal protection is trade secrets. And trade secrets, there's a Copyright Act, there's a statutory enactment of the federal government that protects copyrights. Trade secrets are not statutorily a creature of common law. They basically, because people in the past have enforced trade secrets, they are now protectable again, should you need to enforce them in court. But the ability to have a trade secret turns on whether the thing you have is valuable and whether it is in fact secret. Have you kept it confidential? Have you done your due diligence? Can you show somebody that you have been able to keep something secret? Only then do you have rights in that trade secret. Finally, there's patents. Patents, again, is a statutory right. It's an enactment of the government of Canada. There are patent rights worldwide. Patents generally are not something that people think about when they're doing database creation or data creation, but they're an interesting tool that in certain circumstances can benefit you. And if you're able to obtain a patent, because the hardest barrier is obtaining the patent in the first place in this realm, they can be very powerful, very effective, very powerful, very profitable. For each of them, for data, it also presents all sorts of risks, privacy risks and obligations, possession risks. If you don't actually hold your data, somebody else is holding it for you, what does that mean? And there isn't yet data negligence, but there's a hint that I'll get to later that there's going to be such thing as data negligence. So, copyright, skill and judgment. I'm not going to delve into it in detail, but the case that established it was the CCH case from the Supreme Court of Canada. It depends upon the application of skill and judgment. There's the quote from the judgment that begins to explain what it means. But really, the more useful and interesting thing is this. These aren't every case, but it's a series of cases that have considered whether data is a protectable, copyrightable asset in Canada. Teledirect back in '97 said the yellow pages, that's a protectable asset. Somebody put the work into collecting all the phone numbers, but the little advertisements, I don't know how many of you remember the yellow pages, but they had the little block advertisements. Those are not protectable. There's nothing really particularly unique about them. There's the Ital Press case where somebody had put together a directory of Italians in Western Canada. That was protectable. It took work to collect all the names of Italians and their contact information, put it together in a directory and sell it. There's the BNS Publications case, and that's similarly a directory. So it's people to contact in the oil and gas sector. Once again, it was copyrightable as something that required skill and judgment. GSI case, that was a really interesting series of cases out of Alberta where seismic data and true data, seismic data was found to benefit from copyright protection. And I have a bit on the next slide. On the other side, and this may or may not make it easier for you, there was a denturist case from 2014 in the federal court where 5-digit codes that were used to talk about services that were provided and the descriptions of what each code meant, that wasn't protectable. And if you're scratching your head a bit at that I understand that. The line between what data is protectable and what isn't is to some degree a matter of the judge you get in front of, but it's generally the case that what you need to have is some complexity. The denturist case on my reading turns largely on the fact that there wasn't anything particularly complicated or novel about the data. Whereas if you're collecting seismic data, well, that's difficult to collect, it's valuable, and it's something that once you put it together is an asset you can sell. So for the GSI case, I want to point it out and take one more second on it for this reason. GSI considered this geological data, and there's a little picture from the case about how it was collected. For those of you who've seen various types of radar-ish scanning, this was similar to that method. You bounce certain waves off of the bottom of an ocean, they come back, they tell you what's beneath, they tell you the layers. The court in that case decided that data that was both raw and processed was protectable. And when you say what skill and judgment does it take for the raw data? Well, the choice of what to collect and the choice of what to record was considered to be sufficient skill and judgment. So you can get database protection in the contents of your database if it takes a difficult decision to decide what data specifically to collect. Do you collect these 3 data points but not those other 2? Why? Have you exercised skill and judgment in making that decision? You may have a copyrightable protection. However, I say all this, and Monica will hit on this later, but this becomes critically important in licensing. It isn't that challenging to create a database copyright. That's great for those of you who are looking at creating data as an asset. However, you need to be doubly careful because if you give that data set to someone else and they start manipulating it, well, that's going to be a distinct copyright. And you have to think not only about your data when you start, but you have to think about the new copyright that's created in the hands of another person if you've licensed it to them to use. That means a lot of important documentation about who is allowed to touch what, when, and what comes of the product. Just as an interesting additional point, both the US and the EU have similar regimes, and we won't talk about them in depth today, but if you're interested, you can go look. The US has something specifically considered a compilation copyright, and the compilation copyright has similar contours to what we have. A compilation copyright extends to the material contributed by the author. So again, here's the thought. Data, you didn't create. You're not the person that determines where the seabed lies. However, when you collect it and put it together, it's the fact of collecting it that allows you the copyright. What does that mean for enforcing it? It means that if somebody else goes out and collects exactly the same data, you couldn't do anything about it. But if somebody took your data set and started to use it, you could. It's the addition of the organization and the choice of what to collect that you have protection over, not the underlying fact. So you can't prevent other people, unless you're creating that fact, you can't prevent other people from using the fact using copyright alone. For the EU, they actually created a statutory enactment called the database right, where they added another layer of protection. They have much the same copyright regime as us, but they added a layer of protection on top of that, where you can protect the contents of a database via copyright. So it may be more possible to protect your data when you're dealing with EU parties, and it's something you have to consider jurisdictionally where you might be allowing your data to flow. All right, trade secrets. The critical difference between trade secrets and copyrights is this. There's no statute, it's a common law right. And I try very hard not to use Latin, but there really is no English plain language phrase that expresses what's the next line. It's not an in rem right, but it's in personam generally. What does that mean? When you own a car or a house, it doesn't matter who might come and try to take your car or try to take your house. No matter who it is, you could sue them. You would have a cause of action against them. You have a right in the thing itself. In personam, there are certain things that, if you promise me that you're going to come to work and do work for the day and you don't do it, well, that's something I can attack you for. But if somebody else doesn't come in and work for me today, well, there's nothing I can do about that because they didn't agree to do it in the first place. So there's a really critical difference. Copyright, if anybody infringes your copyright, doesn't matter if you have a relationship with it at all. If anybody infringes your copyright, you may have a cause of action. For confidential information, you have to find a relationship with the person who you say is breaching. It can't just be somebody out there in the world using your confidential information. And that's a really important restriction because it also plays into how you license. You have to be careful about where it flows. You have to be careful about creating an obligation to those people who have that data in their hands. So just to give you some background on trade secrets, a recent case from the BC Supreme Court confirms much the same thing that applies to copyright. Information can be confidential because it is not public, but it can be confidential where public data is taken and assembled in a particular way. And that's usually what a data set is, public information that's been accumulated and arranged in a certain way. And that can benefit from trade secret protection because there has to, but just like with copyright, there has to be some independent thought process involved. This is the slide for you coming back later. This is the slide I think I would emphasize the most. This is a 2018 BC Supreme Court case. It referred to a prior Ontario court case. But this is when data or any other trade secret can actually be considered an asset, a legal right. The court will ask how many of these things are true. So is the information generally known in the public? Well, if it's generally known in the public, if that database has been published somewhere, it's not a trade secret. How much is it known by your employees or others involved in the business? Are you letting every single one of your employees dive into your database and do whatever they want? You're not treating it much like a secret. Are you ensuring that everybody who accesses it has the right protocol and needs to see it? Well, then you are treating it like a trade secret. What else are you doing to guard the secrecy? Are there password protections? Is it held in a particularly secure spot? Are you keeping it on a publicly accessible server? Or are you keeping it on a server where it's got the right encryption? What's the value of the information? Certain data people want to say they own, but if there's no value at all, then courts generally won't protect it. How much money did you spend collecting it? Where the courts aren't inclined to give rights to hold data if you haven't really had to work to get it in the first place. And that's the same point next. It's the ease or difficulty with which the information can be acquired or duplicated. And then finally, and this last point is really the summary of all the other ones, whether you as the data owner or the purported data owner have actually been treating it like a secret. And that means proper NDAs, proper security, proper licensing. All of those things, every time you license data, should be in your mind about ensuring that if you ever got called in front of a court, you could say, I've done all these things. I've treated it like a secret. It is truly an asset. And if you wanted to sue, you'd use the test from the Supreme Court of Canada in the Lac Minerals case from 1989. But you'll see here, it's got to be between two people. One party conveyed the information to another in confidence, and the second person misused it. So it's got to be that counterparty, an employee, somebody you've dealt with. This is an interesting point, and Monica is going to jump in and hit on this one. There's criminal code provisions as well.
Thanks, Matt. Thanks everyone for joining us today. So just a quick note about the criminal code. This is a relatively new provision that came into effect in 2020, and it came into effect as a result of the Canada-US-Mexico trade agreement. And so there's a criminal sanction for theft of confidential information or trade secrets. I've reproduced part of the provision here. And I've noted here as well the definition of trade secret, which you can see some of the elements of the common law analysis that Matt was talking about have been brought into that definition. It's also an offense for obtaining a trade secret, knowing that it was obtained in the commission of offense under subsection 1. So there's a carryover there as well. To ensure protection under these provisions, as I mentioned, many of the items that Matt discussed are relevant, including limiting access to trade secrets, including confidentiality provisions in terms of when you deal with third parties. One area for companies to be mindful in terms of these provisions is when you're hiring employees and ensuring that employees don't divulge information belonging to their previous employer. The punishment under this offense can be severe, so it's up to 14 years in prison. And organizations are also open to this, to liability under this provision. There haven't actually been any cases under this provision, so it's sort of a wait and see approach to see how it's actually implemented by the courts, but definitely something to have in the toolkit in terms of protecting trade secrets. Back over to you, Matt.
Thanks, Monica. So the next few slides, I'm going to go through at what's going to seem like a rocket pace because it's not typical to think about databases this way, but databases and a database structure and process can be protected by a patent if it's truly novel. And if you're able to, it is absolutely worth obtaining patent protection. There was a case from 2019 from the federal court that was a patent that was obtained. Now, this was obtained in 1998. So this was the technology back in 1998. It was considered novel, but it was a network system for storage of medical records. And the records were stored on a server or database and connected to one another. And somebody in 1998 thought of this novel way to connect medical records, and they obtained a patent, and they've had the benefit of a monopoly for quite 20 years in connecting medical records to one another in a particular way. In 2019, there was a decision of the federal court that confirmed that this patent and the claims of a patent are the parts of a patent that are most critical. They define the legal rights. That a computer readable storage medium holding a data structure that has a collection of data elements and pointers to different sources of data was patentable. And they found that it had been infringed. So it's going to be difficult at any time in the future to obtain a patent on database structure because you have to be truly novel. You have to have thought of something that nobody else has before, and you have to obtain a registration. But if you're able, it can be an extremely powerful right. The other way that patent issues can sometimes intersect with data is this. Patents can be for systems or methods. Systems and methods can be about the collection of data. So in the Farmobile and Farmer's Edge case, which was recently tried in the federal court, there was a system that was intended to capture, process, and share farming operation data generated during the use of a farming vehicle in well, usually in the field, but usually out in the farm. And although the data itself wasn't patented, there was a claim that someone had infringed the patent and had used the infringement to collect data about what happens on a farm and what benefits and whatnot. And one of the remedies that was sought was the disgorgement of the data. If you infringe the patent to obtain that data is an asset and should be turned over. Now there's the courts currently sitting on that case, and they're going to release it in the coming months. But it's an interesting way to obtain data rights that is outside of the normal form, which is to say, based on the Monsanto and Schmeiser decision, which essentially confirmed that if you use or infringe a patent and you get a benefit from that, we all know data is an asset that provides big benefits. If you infringe a patent to get data, well, you might have to turn that data over. You might have to disgorge that data, just like you might have to disgorge money. So it's a lightning quick review of all the different legal regimes. But I think, hopefully, as Monica goes through the next part, you're going to get a sense of why each of those series of thoughts is important when you're thinking about licensing and securitizing. Monica, over to you.
Great, thanks, Matt. So in this part of the presentation, Matt and I are going to tag team a little bit. We're going to talk about licensing data from both a drafting and negotiation perspective, and then Matt's going to talk about jump in with comments about what happens on the enforcement side and how agreements can be dealt with in terms of those aspects. So just generally, data licensing and use of data are obviously really broad topics. There's variation based on industry, the type of data that is collected, and when you throw personal information into the mix, you're also dealing with privacy laws. The privacy aspects of data can be a significant issue, keeping in mind that privacy laws are territorial. So one data set containing personal information may involve multiple jurisdictions and multiple privacy laws, whether based solely on territory or on the type of data collected, such as specific privacy legislation that applies in the healthcare context. I believe you've recently had a session on privacy, so I'm not going to spend too much time on this issue. I just really wanted to note that there are often privacy issues that will play a big part in data licensing arrangements, particularly when it comes to representations and the allocation of risk. So the theme of variation in terms of data licensing continues with subject matter and how data is treated and reported. There's so many types of data that one could be dealing with, everything from consumer data to market data, research data, real-time collected data from Internet of Things devices, and data sets that may be provided by a data broker. There's also a wide range of variation in terms of how raw data is formatted and analyzed, whether it's through the application of algorithms or machine learning models. And artificial intelligence is certainly impacting how data sets are used and new data sets are created. And then on the usage end, there's also so much variation. Licensees may want to use data for various purposes, everything from gathering big business intelligence all the way to developing their own products and services using that data. Despite all of that variation, there's some commonalities in the treatment of data and licensing contracts. So what we wanted to do in this section of the presentation is focus on a few key contractual aspects and talk about those in a bit more detail. Before I get into that discussion, there's a few broad principles to keep in mind. One aspect that runs through all of our discussions today is that licensors and licensees are going to have competing interests in license negotiations, and a lot of what comes out in data licenses practically comes down to bargaining power and the ability and willingness to negotiate. And as you've seen, there's considerations to keep in mind based on the type of intellectual property right that is involved. So that's definitely another broad consideration to keep in mind. Another broad aspect to keep in mind is that a license is first and foremost a contract. So the general principles of contract law are going to apply to all license agreements. So looking to the aspects of contracts that make a contract valid, things like offer and acceptance and having valid consideration, those are essential in license agreements as they are in any other type of contract. When promised results don't occur or payments are not made, parties are going to look to the contract as the primary means to enforce their rights. And if the parties haven't paid due care and attention while drafting the agreement, difficulties often arise in the context of a dispute. So going into a licensing arrangement, it's really important to take the time and enter into valid and enforceable contracts that address all required aspects, whether those are licensing specific or more generally contractual law related specifics. That might seem onerous. There may be time considerations involved or other pressing issues, but carefully considering contractual terms in advance will definitely lead to a more productive contractual relationship and will lead to more effective dispute resolution if disputes arise. The last broad principle I just wanted to touch on is a license is essentially a permission to use or otherwise deal with another party's IP, so that all of the clauses we will discuss will involve scoping out that grant of a right to use someone else's intellectual property and ensuring that risks are appropriately balanced for each party and that each party's rights are clearly known going into the arrangement. So the clauses we're going to look at specifically with respect to license agreements are the grant clause, ownership provisions and derivative data, representations and warranties, and then we're going to round out on limitation of liability and indemnities. Next slide, please. So the first clause we're going to talk about is the grant clause, and that is really the most important clause in a licensing arrangement, whether it's dealing with data or some other type of right. And so it really needs to be set out clearly as it establishes the scope of rights being granted to the licensee. And here's the first case where we see these competing interests at play between licensors and licensees. Licensors are going to want to, for example, control the data as much as possible, whereas licensees are going to want to seek broad usage rights. So on this slide, I've just shared an example of a typical grant clause. And I just wanted to go through and look at each of the elements in the clause, because the provision raises several key aspects in data license agreements and raises important considerations to be addressed in other parts of the contract. So in this case, the license is non-exclusive, meaning that other parties have a right to use the data. The license may also be exclusive, meaning no other party, including the licensor, has the right to use the data. There could be variations on that. For example, the licensor may say the license is exclusive, but I want to use the data, so I'm going to reserve the right to do that. Those rights then may be limited by field of use. In this case, it's called the permitted purpose, or by a territory of use, so that a licensor could ultimately grant multiple exclusive licenses based on the intended use or territory. Next up, how will the licensee be able to distribute the data? If the data is confidential information, for example, then there should be limited rights to display, as overly broad display rights will result in loss of proprietary rights over that information. However, internal display of data, such as display on dashboards or through reporting, won't necessarily reveal data in breach of confidentiality provisions to third parties, thereby protecting the confidential aspects of the data. Another aspect to consider is how will the licensee access the data? Using the word access in this clause refers to accessing the data perhaps through a data portal or an API, an application programming interface. If the data will be provided in a separate instance to be installed on the licensee server, different wording may be appropriate, perhaps a right to reproduce in that case. A general ability to use the data set out in this clause can be problematic. What does use actually mean? I cannot tell you how many times I've seen license clauses that say there's a right to use without further specification. So the usage of that term in terms of using data needs to be more specific, either by defining the term use itself or by setting out specific rights instead, such as, is there a right to analyze or reproduce data? If the data is protected through copyright, the various rights inherent in copyright will need to be considered and addressed. Also, does use of some form need to continue after the contract? If data has been incorporated into a process of the licensee or otherwise aggregated or used, there may be a need to have ongoing rights in the data for the licensee. And so licensees will want to ensure that those aspects are addressed in the contract. Permitted purpose is another key aspect in this grant clause. How will the licensee be able to use the data? For example, is it only for internal use? Will the licensee be able to create derived data? This clause is pointing to the creation of derived data by referring to modification. As we'll see when we discuss ownership, derived data and new data requires some attention in a contract. This aspect again points to the critical nature of definitions of license agreement. What does permitted purpose clearly mean? The parties need to scope that out. This grant clause doesn't have a territorial restriction, but is such a restriction appropriate in a specific use case? Particularly where data involves personal information, territorial restrictions will be important. Finally, restrictions on transferability and sublicensing and permitting revocation of the license are meant to protect the data from the licensor's perspective, but may not necessarily align with the licensee's interests. So those terms may be negotiated. Licensees will want to be very careful with rights to transfer and sublicense, as those are situations where the licensor may begin to lose control over their intellectual property rights. If sublicensing is permitted, for example, it needs to be strictly controlled and limited. Licensors will want to ensure that the licensee remains responsible for any use by a sublicensee and will want to flow down license terms to the sublicensee to ensure that they comply with key provisions of the license. Transferability will also be problematic where the data is confidential information. Matt, did you want to add anything on this?
I think you hit on the key points. I think for me, it's you need to understand your rights because, as you say, a trade secret, you would never want to say that somebody has the right to display or distribute. However, for a copyright, it's far less of a problem because your rights don't depend on it being kept secret. So all of the things you just talked about, including the possessory rights, who are you allowed to give it to and why? The amount of attention you pay to each of them is really going to depend on what rights you have in the first place. But I think that's fully explained by everything that you said.
Okay, great, thank you. So I think we can move on then to the ownership portion of the presentation. So this is a big one. Similar to the grant clause, it's critical to deal with these issues in a license agreement. And so ownership and creation of derived data are often key aspects in data license negotiations, particularly where data is generated, for example, as part of a services arrangement. So again, we have the competing interests of licensors and licensees. Licensors will want acknowledgements of its ownership in the agreement. And to that end, we'll often focus on the definition of licensed data. In some cases, a narrow definition of licensed data is appropriate, such as in a data fee arrangement where the customer isn't permitted to generate derived data. In other cases, however, such as a services agreement context, the customer may want to include a different definition, where the customer is retaining ownership or wants to gain ownership over any data that's derived by the vendor in performing services for the customer. This again is particularly important in the context of personal information. In this case, a vendor may seek to have license rights to the data to allow it to create data aggregations or to use the customer's data in its own data sets. So thinking about ownership of data coming into the arrangement and data coming out of the arrangement in the license agreement is critically important. I often think of ownership issues in license agreements being similar to the concept of nesting dolls, the little dolls that you take apart and there's another little doll and you keep going. So one set of issues in ownership definitely leads to another, and parsing out all of those permutations and issues that come up for ownership in the data licensing context is really important to address in the contract. Another big set of issues is net new data that might be created and derivative data that may be generated. So derivative data may be sufficiently different from the original data set so that the original data cannot be identified from reverse engineering the derived data, or it may be a modification where the original data can still be traced. In the first instance, the derived data may be a derivative work, as we've heard Matt talk about under copyright law, thereby creating a new set of intellectual property rights. It's really important to define derivative data in the agreement. One option is to refer to the concept that I mentioned, that derived data is that from which the licensor's original data cannot be reverse engineered. Again, the context and the type of data that you're dealing with is going to be really important. If the license allows modifications of data, a derivative work may be created. The parties may not even be anticipating that, and ownership under copyright laws will rest with the creator. It's important to address ownership of those derivative works in the contract. So if we're dealing with transfers of ownership, wording requiring assignment of rights and waiver of moral rights on the copyright side would be required. Similar to derivative data, net new data that is created should also be considered. Who owns that data? Similar considerations on ownership and process aspects arise as those that were raised under the derivative data discussion. So who owns the data? Do we need to put into place any assignments and waivers to make sure that the ownership rights end up where they're intended to be? So in summary, the agreement should address ownership of derivative data and new data and how that data can be used by each party. A party may be willing, for example, to give up ownership rights, but may be looking for rights to use the derived data or the new data through another licensing provision in the agreement. So you'll often see license agreements have this license from the licensor and then a license back if the licensee is gaining ownership of data under the agreement to the licensor for certain limited purposes. So definitely an area where there's competing interests, again, between the licensors and licensees, and careful drafting and analysis is often involved in getting those provisions to where they should be. Related to ownership are restrictions on the use of data in a contract. So there'll be provisions, for example, on not being able to reverse engineer or decompile the data, restrictions on making the data available to other parties, and not obscuring notifications of IP rights that may be included with the data. Where data is protected as confidential information, confidentiality provisions in a license agreement are key. Generic confidentiality provisions, such as a provision that might say the licensee is going to treat the licensor's confidential information in the same way as it treats its own confidential information may not be sufficient depending on the data that's involved. So here the licensor is going to look for detailed and specific confidentiality provisions, including possibly provisions requiring the licensee to treat the data in accordance with specific industry standards. Security provisions are adjacent to confidentiality provisions in terms of importance, and having required security protocols in place will serve to protect data as confidential information. Also relevant for data protection are audit provisions, allowing a licensor to view how data is being used and whether it's being used in compliance with applicable laws. That aspect is particularly important where personal information is included in the data to ensure that privacy laws are being complied with. Matt, did you want to share any thoughts on this section?
I think for me, Monica, the best thing on this point was your and my discussion about how lawyers need to hire service providers that provide SaaS services. And it engages so many of these problems. When somebody's providing you a SaaS service, they're probably holding your data. They probably shouldn't own it. And particularly, Monica brought up the issue of industry standards. Lawyers have unbelievably strict and rightly so obligations on what can be done with confidential client information. Well, it's not sufficient for us when we hire a service provider to say, do what you do with your own confidential information. We have to ensure that it meets the standards that we are held to, and it goes into the hands of that service provider. So it's, you know, these are near and dear to our own hearts because we've been struggling with them, but they're good examples for why you can't simply accept what somebody else does, particularly if you're within a regulated industry.
Yeah, no, that's a great point, Matt. Thank you. So moving on to the next couple of issues. So warranties and indemnification and limitation of liability. So this set of issues is really dealing with risk allocation. And so it's really about how the parties are going to balance the risk that that occurs in a licensing arrangement and how they're going to deal with that. Matt, did you want to move to the warranties page?
Sure. Here we go.
Thank you. So disclaimers of representations and warranties by licensors are typical in data license arrangements. And if you think of it from a risk perspective, this makes sense because they want to provide access to this asset, but they want to minimize their risk as much as possible. So from a licensor's perspective, they typically want to provide data as is and as available. They want to exclude warranties, for example, on access to data being uninterrupted or being error-free. Other disclaimers might include that the data won't yield particular results. Another aspect that comes up often in disclaimer provisions is they'll want to disclaim what's called statutory warranties, so that the data is fit for the purpose for which it was licensed or that it's merchantable. So those are all disclaimers that a licensor is going to look for. Licensees, again, will have competing interests, so they're going to want to seek representations from licensors, for example, that the licensor has the right to provide the data to them and that the data is reasonably accurate. If the data involves personal information, the licensee is going to want a suite of representations around that, stating that all the required consents have been obtained and that the licensing of the data is in compliance with all applicable privacy laws. What happens in the warranty context will boil down to the type of data being licensed and the bargaining power of the parties. Matt, did you want to add anything on warranties?
I think I'll let you move on to the next one.
Okay, great. So continuing with this whole concept of risk allocation, indemnification is another aspect to consider, and it really involves shifting risk from one party to the other party. So basically, indemnification requires one party to agree to cover damages and settlement amounts and to defend and absorb litigation costs for a defined set of risks, typically related to third-party claims. So where a party outside of the contract sues one of the parties to the contract. How that risk is shifted will depend on the bargaining power of the parties. Again, a general principle is that the party that is best able to control the risk indemnifies the other party. For example, in this situation, licensees may look for protection if the licensor does not have the rights to license the data. So they may be looking to an intellectual property infringement type indemnity. Licensors, on the other hand, may look for protection in terms of how the data is used by the licensee. An important aspect to keep in mind with indemnities is they're only as strong as the ability of the party to stand behind it. So insurance provisions are really important when you're dealing with indemnities, because that will ensure that there's sufficient resources to backstop the indemnities, to make sure that there's actually access to funds there to fulfill the indemnification claim. The other aspect rounding out this sort of trifecta of risk allocation is limitation of liability provisions. And this is also an area where licensors and licensees are definitely going to be at odds. Licensors are going to look for limitations of liability through monetary liability caps, as well as by excluding certain types of damages. So for example, they may want to exclude damages for lost profits or damage to reputation, or typical types of damages that are included, such as indirect damages. The parties should definitely consider whether there should be exceptions to liability caps. For example, if one of the parties is grossly negligent, it may not make sense for those caps to apply. In the context of intellectual property infringement or breach of applicable laws, again, there could be questions around those caps. Limitation of liability negotiations may lead to levels of caps, for example, where there's a general liability cap and then what we would call a super cap for a higher amount available for more critical matters such as privacy breaches or intellectual property infringement. So warranties, indemnities, limitation of liability are the three aspects that you want to consider when dealing with risk allocation. Matt, over to you.
Yeah, I think for me, the critical thing here is to bring you back to the trade secret discussion. Trade secrets are brittle. And what I mean by brittle is that when your trade secret is disclosed into the world, it ceases to be an asset. It now becomes publicly known. Anyone can use it. You have no rights at all. So there's a massive risk in that. And therefore, when you're looking at licensing a trade secret, and I know this isn't data, but the recipe for Coke, if that got disclosed, and it would be as easy as somebody sending an email, you'd have a massive value loss in no time at all and no way to pull that back. So if you're dealing with valuable confidential information, you really need to focus on this. You need to ensure that there's a super cap and ideally insurance that's sufficient to cover the loss of value that would happen if your confidential information got disclosed broadly. And to go with that, you need to ensure that there's an injunction provision. Anytime you're licensing confidential information, you absolutely need an injunction provision, because sometimes, I've had this once, it's possible to stop a leak. You can catch it when it goes to the second and third party before it goes out broadly into the world. And an injunction is the only way that you'll be able to stop something like that once it's begun. So it's critical when you're dealing with trade secrets to think along those lines as well. So Monica, should I flip to the next?
Yes, please.
So I think, Monica, I don't know if you want to jump in here, but this is just a potentially overwhelming, but hopefully useful graph of the ways that you can sue one another when you're involved in data breaches. So there's a licensor and a licensee, and they can sue each other based on contract claims or trade secret claims or copyright infringement claims. But usually the main claim is going to be a copyright claim. But when Monica was talking about indemnities against third parties, there's different sets of third parties that are engaged with different rights. When there's a data subject, there's a privacy or a contract issue. We saw this class action case against Facebook for misusing photographs to promote themselves. Well, there's a subject of a photograph and they're allowed to seek some sort of redress. But so too, the privacy legislation, frankly, is more challenging these days and more important. There's a recent, and I'll hit on it in a second, potential for a class action for a privacy breach, and that's becoming quite frequent. Authors can always sue for copyright. It doesn't matter who you are or where the copyright is. The author can sue anyone because, again, it's that in rem right. So you have to be aware of who's going to bear the risk if an author comes out of the woodwork. And in Canada and in certain countries of the European Union, there's not only authorship rights, Monica averred to this, there are moral rights, the right to be associated with your copyright protected work. So you have to get both an assignment and a waiver to mitigate against those risks. And then, as Monica said, representations about quality or fit for purpose, the end user may try to bring claims related to the accuracy or the quality of data. And that will only usually be in respect to the licensee because there's no relationship with the licensor. So that's another third-party claim that you should be thinking about when you're drafting the indemnities and the warranties and the limitations of liabilities. Monica, do you want to add to those points?
No, thank you.
Finally, there's a red line. This red line I put there because trade secrets can only flow to an end user if the data licensee has forced the end user to keep things confidential. So in order for you as the owner of a trade secret to bring a suit against an end user, that end user has to be under an obligation to keep confidential information confidential. So you have to ensure through your contract that that obligation and right is passed through to any end users. Otherwise, you're just out of luck. There's nothing you can do about it. I'm not going to spend much time on these, but happy to talk about them. There was recently a class action certified for a data breach against CRA. And there were two grounds: intrusion upon seclusion, which is a newly created tort, and negligence. So we will see when that class action, if it goes forward, whether those are valid claims for data owners, whether you can be negligent in your handling of data, and whether disclosing personal information gives a class action right for intrusion upon seclusion. There is always, for trade secrets, a risk that you would face if you're a licensee, a breach of confidence or a breach of fiduciary duty claim. There's unfair competition if you use confidential information against a licensor or an unauthorized individual who obtained the information tries to use it against the owner of that confidential information. And then there's fun things that arise in the context of AI. There was a recent case filed down in California that alleges that in using code, because it's a program called Copilot, an AI program that proposes code. In creating that AI, Microsoft, GitHub, and OpenAI primarily misused software that other people had put on GitHub publicly, and that license or that claim is a result of allegedly not adhering to the Creative Commons licenses that were in place, the open source obligations that those parties had when they downloaded that. And if you as an end user of this Copilot AI find yourself copying code, you may end up on the hook. But for the time being, it's just, it's an important and interesting additional consideration when you're looking at using large data sets to train AI, and we're just touching the tip of the iceberg on that issue. So I won't delve too deeply into that. I'm very conscious of our time. We have a couple of questions already. Monica, is there anything else you want to add before we jump over to questions?
No, I think I'm good. Thanks, Matt.
Okay. So it's amazing trying to get through all of this content in just an hour, and how much there is to deal with and how many things there are to think about. There's a couple of questions in the Q&A panel, and we're happy to hit on those or have any other questions from anybody. One of them I could just deal with really quickly. There was a question about whether the GSI case involved patents, and the answer is no. It was just a copyright case, but it engaged a very difficult, thorny issue that's distinct. In that case, there was data that a party was obligated to submit to a government body to obtain certain approvals. So in so submitting, the question the court really grappled with is what happens? You know, if you have data and you have to use it to obtain an approval from a government body, you have to check with the government body about how that affects your rights, because it may be that it's no longer a trade secret. Monica, I don't know if you have the Q&A panel up in front of you.
Sorry, yes, I do. Did you want to answer the Monsanto question, Matt?
Sure. The Monsanto case is totally distinct from data. The reason I cite it is because there isn't a case on point on the Monsanto or on the issue of whether data has to be disgorged upon patent infringement. What the Monsanto case was about genetically engineered grains and whether there was a right to the genetically engineered grains, and if there was, what Monsanto could obtain as a result of finding that somebody had infringed it. And the court gave a nice broad discussion that said, essentially, if you use a patent and you're not allowed to use the patent, the benefit that you get, whatever form that takes, might be something that you have to give up, not just money, but other assets. So that case is generally what it's relied on, but it's not specifically relevant here. It's just a foundation for making that argument. So there's the question that we got about whether it's defensible to create your own suite of licenses if Creative Commons aren't doing the job.
Yeah, I can
think
jump
Monica's
in
got
there. Yeah, definitely. If Creative Commons the templates aren't working for you, you can definitely look at creating your own set of usage licenses. That would be totally fine.
Yeah, licenses are great. They can be creative and different and do whatever you need them to do generally.
You can also come up with templates. So if you have like a particular use case that comes up a lot of clients will have templates generated for different use cases.
We've got a question about whether medical data is patient-generated health data or it comes from a hospital or private practice. This to me, and Monica, I'd be curious about your views. This to me is critically important for copyright. The person who owns it is the first one who reduces it to a tangible form. So generally, if you're looking at it from the copyright lens, it's the person collecting it, the hospital or the medical center. From a confidential information standpoint, it's usually that of the hospital or the clinic, but it's not always, and that'll depend upon the relationship. But it is probably that of the hospital, which is, and the answers to those two questions, I think, is largely why privacy laws were created, because there isn't something that inherently vested in the individual that was the subject of the data. And so we had to statutorily create something that when data is about you, you've got some rights in it. Monica, I don't know if that tracks to what you're thinking.
Yeah, I think the privacy lens definitely comes into play there, and the specific laws around health privacy legislation would definitely impact in terms of ownership of the data. So important to keep those in mind as well.
Yeah, and really, when you're thinking about health data, I know there are specific regulatory regimes, so I'm going to pull it out of health data and put it in another context. In data about people, about advertising, think about what Google and Facebook collect about all of us. It's not health data, but it is your data. That's why they generally take their data, adjust it to a form that is outside of privacy legislation, and then they start playing with it and monetizing it and using it for their various purposes. Because what they want to do is get that data outside of the reach of privacy regimes so that it can be used as an asset. And that requires making it anonymous or de-identifying it, depending on the regime that you're talking about. We have a question about what kinds of IP protection are the most cost-effective and important. That's an unbelievably, it's impossible. It depends upon the startup. So, but think about this. It's easy to create trade secrets. All you have to do is do your contracts right. You get somebody to write your NDAs and make sure you always use them and get a couple of good processes. Well, there you go. You got a trade secret, so it's cost effective. Are you the type of business that really needs to have a trade secret? Maybe or maybe not. Depends on what you do. Copyright, likewise, is created upon the creation of a work. You can register it, but you don't have to. So it's a cost-effective way to get benefit. But if you're an innovative company that's coming up with new technology, patents are expensive, but they are, I would say, one of the most valuable forms of IP if you can obtain them. So it depends a lot on your business model, but a couple of those forms are quite easily accessible right out of the gate, so long as you're paying the right attention to how you document and record things. I don't know, Monica, do you have a different view as the person who tries to monetize them more often?
No, everything you said makes sense. I think we didn't talk about trademarks much today because it didn't really fit with our presentation, but that protection also exists at common law, but you get sort of super protection if you go the registration route, and that the registration route, if there's no complications, is not that expensive. So if your brand is something really unique, that is definitely a aspect to consider.
Jen's hopping back on. I don't know, Jen, do you have another question, or we run out of our time?
Perfect. I think as we're heading up to the top of the hour, was seeing if there was any last question that was coming in from the from the audience. And there's maybe one final one that you both can touch upon before we close out is, steps that you suggest for new entrepreneurs that are focused on innovation, but without a legal team. Maybe some insights there before we close out.
I think from my perspective, the discussion that we just had about different types of IP assets to consider is one to keep in mind. I think having the whole concept of template agreements is good and bad because some people rely on them too much. But if you are using or plan to use the same form again and again, that's one area where you can get a lot of boxes checked, for example, by having a standard form confidentiality agreement that you always enter into that's been vetted through legal is one example of where a template could be really effective.
Yeah. And I would say, I would focus on confidentiality if you're focused on innovation, because just like a trade secret, you need the confidentiality to own the trade secret at all. But just like a trade secret, if you disclose your invention, if you've got a great invention and you accidentally give it out at a trade presentation, that can mean that you can never patent the technology based on some consideration. So a patent requires novelty, and that means that you can't publicly disclose it. That doesn't mean you can't share it. You get a proper NDA or a proper confidentiality agreement with your research scientist or with people who are involved in deciding whether it's something that should benefit from patent protection. Put those protections in place. You can talk to people about your invention. If you just go out there and talk about your invention to the world, you can't get a patent, you no longer have a trade secret. You're quite limited in the legal routes you can use to try to create value.
Thank you both so much. As right before I hand it back to Sydney to close us out, just on behalf of the Supercluster and our monthly IP series, huge thank you to you both, Monica and Matt, for taking time out today, for sharing these insights, and perspectives sort of with the members that are on and giving them things to think about as they go off into their organizations, and also for sharing your contact details for folks who may have other questions. And we look forward to seeing you in the future for some future interactions. So Sydney, I'll hand it back over to you. Thank you, everyone.
All right. Thank you to all of you who registered, watched, and participated today. And a huge thank you to our speakers, Matt and Monica, for all of your time and knowledge on this topic. A reminder that a recording of the webinar and a PDF copy of the presentation given today will be sent out within the coming days. On behalf of all of us, have a wonderful rest of your week to wherever you may be tuning in from.
Thanks, everybody. Thanks, Jen. Thanks, Sydney.
Thank
Thanks, everyone. Bye.